The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Seated. We have 3 cases that are before the court this morning. The case of Iowa Supreme Court Attorney Disciplinary Board versus Scott Bixenman is hereby submitted without oral argument. First case for oral argument today is Planned Parenthood versus Kim Reynolds and the State of Iowa and the Board of Medicine. Are the parties ready? Thank you. Mr. Langholz, it's my understanding you will be going first. And your time is going to be shared, and I'll let you guys be in charge of that division of time.
Thank you, Chief Justice Christensen. May it please the court, Ms. Bettis Austen, Mr. Schandevel, and Mr. Hurley. 2 years after this court declared a 72-hour waiting period unconstitutional, the Iowa legislature repealed that statute and replaced it with a 24-hour waiting period. Planned Parenthood sued to block that statute as well, and the district court agreed, cutting short the state's opportunity to defend that statute and granting summary judgment to Planned Parenthood for 2 independent reasons. Both of those reasons were wrong. First, relying on legislative process and policy considerations, the court declared a single subject violation, even though when properly conducting the analysis and looking at the text of the act, it embraces, both provisions of the act embrace one subject of the regulation of medical procedures. Second, the court, relying on issue preclusion, prevented the state from defending the merits of the constitutionality of that statute at all, even though the issue of the constitutionality of a 72-hour waiting period is not an identical issue of the constitutionality of a 24-hour waiting period.
Didn't the district court in Planned Parenthood, the first Planned Parenthood case, find that the 72-hour waiting period did not affect choices of women? I mean, there was a finding of fact to that effect, was there not?
The district court decision did not make that finding of fact. Again, the district court concluded that there was evidentiary support. You know, I think there were studies, and there's a distinction between what the district court found and what this court on appeal concluded the fact findings were. But the district court relied on a study that an 8% in Utah, I believe, of women would change their mind based on a waiting period statute.
Rejected that, and this court, I think, repetitively said that the 72-hour waiting period did not affect women's choices. If that is true, and I understand you challenge it on the 8% rationale, but if the court was right in Planned Parenthood, the previous Planned Parenthood case, how would a shorter period advance the state's asserted interest?
A couple issues with that, Justice Apple. I think, first of all, when we're talking about these sorts of decisions in a constitutional case, these are constitutional facts, legislative facts, and that's part of why it appears part of why this court didn't give the district court any deference in the fact finding, and why it can consider additional facts on brought in by Amicus on appeal when we're talking about factual findings deciding a constitutional question like that, rather than adjudicative facts specifically about this case and a particular woman and the impact on Planned Parenthood. And it inappropriately frees constitutional doctrine if issue preclusion can apply to a constitutional fact like that.
Extrapolate from the Utah study that 8% of women would change their minds due to the waiting period. How many additional babies would be born on average in Iowa each year?
Of the math on that, Your Honor.
Perhaps, sir.
And those are I mean, ultimately, laying out, those facts, I mean, Planned Parenthood points out there have been, additional studies since that time. We haven't had the opportunity to fully litigate those, to present our case to the district court here about what the current state of the facts here in Iowa or other expert studies are about the potential implications of those facts with respect.
Ever any issue preclusion, or maybe there never is? What you're saying is we just have to litigate it time and time again. I mean, so, you know what I'm saying. I mean, it's 24 hours, 36 hours, 28 hours, 42 hours. You would have de novo review on each occasion, I take it.
If I'm understanding your question correctly, Justice Apple, you're limiting the question to statutory, constitutional challenges to statutes, to waiting period statutes. I mean, certainly the state's not arguing there's not issue preclusion at all, in the state of Iowa. But with respect to a new statute enacted by the legislature, that's correct. The state should have, statutes are cloaked in presumptions of constitutionality. They're passed by a co-equal branch of the government, and the state should have the opportunity to defend that new statute on the merits. I'm not foreclosing, I suppose, that there could be a discrete, adjudicative fact that, is indisputable, that not a legislative or constitutional fact. If there was some sort of question about Planned Parenthood's authority, or an employee with Planned Parenthood or something like that, that is a discrete, concrete fact in a case that has none of the other concerns that should give the court pause about using issue preclusion in a constitutional context. There may be maybe a situation like that, but again, here, that's not what happened. The state's been precluded entirely from addressing the merits of this issue. Turning to the single subject challenge, that analysis really should start with the text of the Constitution. Article 3, Section 29 says, "Every act shall embrace but one subject and matters properly connected therewith." It says an act, not a bill, not legislation. We look at the act to decide what the single subject is. And if you look at the act on page 495 of the appendix, there's two provisions. One of them is the one that Planned Parenthood challenges here. It regulates the medical procedure of abortion. The second regulates the when a court can order the withdrawal of life-sustaining procedures from a minor child over the objection of the parent. The legislature itself tells us on the title that this is about medical procedures. And this court's precedents make clear, this should be a deferential standard that the court should search. So even if this standard doesn't, if that subject, isn't acceptable, there's many other subjects as well, whether it's the parent-child relationship or protection of health and safety. The district court didn't conduct this analysis at all, really, other than summarily concluding the subjects were different, and instead went to the legislative process. And Planned Parenthood invites this court to do the same, focusing, primarily on a germaneness ruling. And again, if you look at what that ruling was on, page 498 of the appendix, the presiding officer in the House concluded that the amendment adding in this abortion regulation wasn't germane to, a technical amendment that was pending on the floor. That was, procedurally how the bill went back to the House and was, subject to amendment. There's really no question that, this technical amendment that changed numbers and added a definition, that abortion wouldn't have been germane to that amendment, and in all likelihood it may not have been germane to the underlying bill as well. But that's not the question. Our Constitution, we don't have an original purpose clause in our Constitution like many states do have, which do prevent changing a bill's subject as it moves through the legislative.
Mr. Langholz. You're talking about how the legislature came up with this bill and they haven't had an opportunity to fully have that out there. But help me understand the logistics of how this bill came about. It's definitely a controversial topic. Am I correct that it was voted on in the dead of the night without notice to legislators or the public?
On it, did start in the evening, and completed in the middle of the night. I mean, that's correct as a, yes, the same notice that applies to the legislative process throughout,
Session, but was there notice that this particular topic would be at issue?
I guess it depends on how one is, considering notice. There was, it followed the same rules of procedure with respect to notice, of any provision. The amendment was filed. I believe the record indicates that the minority became aware of the amendment, before it was filed, in any event. In fact, when the Senate passed the technical amendment sending the bill back to the House, the minority leader in the Senate predicted, and urged her colleagues to vote against the amendment, saying, I think this is going to be an opportunity, I don't know what, but there'll be an abortion amendment that comes back when this bill comes back. So I believe that's correct. I believe that's, well, technically the day before, because I think by the time we got to final passage, it was.
Help me understand that the optics of saying the legislature has this job to do and to represent the people of the state of Iowa in what bills get passed and approved by the governor. And yet, were the people of Iowa deprived of an opportunity to really be involved in that decision-making?
The people of Iowa, through their representatives, the legislators, in the legislature, had the opportunity to fully debate and discuss this bill. There was vigorous debate in the process. We have a representative democracy in Iowa, and essentially the people speak through their legislators, and in the Capitol, this was debated. I think stepping back, I mean, fundamentally, while these may be policy concerns, and Planned Parenthood and others who were concerned about this can make the case to their legislators this isn't a practice they should follow, can make the case to the voters that we should elect legislators that would not make a decision so quickly. Those are policy and political debates, and the Article 3, Section 29 of the Iowa Constitution doesn't require any of those things. It requires a single subject. It requires that the act embrace a single subject and matters connected to it, and there's not a requirement in the Constitution that the legislature give notice. In fact, I mean, we have much more notice about the legislative process now in 2022 than we did at the time of the Constitution. I mean, the legislature, even this debate was live streamed. Anyone, could have been watching this, online throughout the process. The amendments, as soon as it gets filed, is available online. Anyone is able to pull that up. In fact, again.
What do you make then of our case law, which indicates, at least in some contexts, that there is a purpose behind the single subject rule that relates to kind of order and procedure within the General Assembly, and maybe that, fair or not, maybe that's not in the text of the Constitution, but at least the cases indicate that there's some procedural requirements that have to be met. How do you deal with those cases?
Discuss procedure, sort of as a secondary matter or sometimes as an introductory matter, explaining the rationale and justifications, oftentimes, when then, applying the proper analysis, the statute is struck down, and it appears to be more an explanation of this is why, we should care and it's appropriate to strike down. I don't believe there is any case that looks purely at the purpose and says, well, this violates the purpose of the Constitution, irrespective of whether or not it violates the single subject requirement. I think the other important point is that, the notice and surprise and those sorts of issues really are more a title issue than a single subject issue. The single subject challenge is focused, the cases have been clear about preventing log rolling, which is, two bills that couldn't, or two issues that couldn't pass independently, combined together, sort of like the frontier days of not being able to roll, your log on your own and needing the help of your neighbors. And that, again, we know didn't happen here either, because this amendment, by coming in as an amendment, got a separate vote. We know a majority of both the House and the Senate wanted to add this amendment, so there's no concern that this couldn't have passed but for it being combined into a larger bill that, the legislature had no choice but to pass the whole thing.
Erred on the preclusion issue and same subject rule issue. What would be the appropriate legal standard for the district court to apply on remand?
State would encourage you to, well, we give you two paths. We would urge the court to overrule the 2018 Planned Parenthood decision and conclude this is not subject to strict scrutiny. And the court could adopt the undue burden standard, or could conclude, as it typically does when there's not a fundamental right, that this is subject to rational basis review. Either of those paths, this statute would apply under. And with that, unless there are any other questions for me, I did relinquish 5 minutes of my time to the Amici legislators, and I see that I'm into that window of time. Thank you very much.
Good morning, Your Honors. Counsel, may it please the court. Chris Schandevel with Alliance Defending Freedom on behalf of Amici 60 Iowa state legislators in support of appellants in this appeal. As Justice Kavanaugh recently suggested at oral argument in the Dobbs case, when a constitution is silent and therefore neutral on an issue like abortion, the courts have a responsibility to be scrupulously neutral on those subjects, leaving them to the people to regulate through their elected representatives.
Board of Education is wrong because the Constitution doesn't expressly exclude segregation.
Here we're dealing with substantive due process rights as opposed to equal protection. But no, Brown versus Board of Education clearly was not wrong. Plessy versus Ferguson was wrong the day that it was decided, and so therefore the court had a responsibility to overturn it when it did in Brown versus Board, which is why.
So we've established that although there is no malfunctioning because of my hand, but in Brown, there was no express constitutional provision related to segregation, but we decided that the larger principles of equal protection defeated segregated schools. That's a fair summary of Brown, is it not?
This court is doing substantive due process analysis, which is what the majority of the court's opinion hinged on in the 2018 decision we're asking this court to overrule. It's important for the court to be guided by neutral general principles of law. Otherwise, courts have the ability to take power away from the legislature and define anything within the word liberty. Yes, Your Honor.
Different hypothetical. What if the legislature passed a law mandating that everyone in Iowa take the COVID-19 vaccine? Would the Iowa Constitution have anything to say about that law? Or is that a law that would not be implicated at all by the Iowa Constitution?
Interest in liberty and personal autonomy would have something to say about that, but the analysis has to be.
In this case, does it not have something to say?
The analysis has to be whether or not, and this is the first general neutral principle the court ignored and failed to apply in 2018, is in order to be a fundamental right, that right has to be a liberty interest that is deeply rooted in the history and tradition of the nation or of the state of Iowa. And we know from the history of Iowa, since 1843, before the Constitution of Iowa was adopted, Iowa prohibited criminalized abortion. 6 months after the Iowa framers adopted the Iowa Constitution in 1858, the legislature passed a law criminalizing abortion in all cases except for the life of the mother, with no quickening exception, no other exception except for the life of the mother. So if the courts are going to read into the word liberty in the due process clause of this Constitution, the court has to be guided by some neutral principles. Otherwise, what happened in 2018 will happen again, which is that power will be taken from the legislature to regulate an issue that has been left to the legislature since the time of the framing of Iowa's Constitution.
Be the views of the all men in the territorial legislature and the views of the all men in the 1857 Constitution and the views of all men who ratified it. Those views control the rights of women in 2022.
That actually brings me to my third point. I was hoping to make 5 this morning. The second general neutral principle was that plaintiffs have a heavy burden to prove a statute's unconstitutionality beyond a reasonable doubt. Of course, that burden was never even mentioned in the 2018 decision, much less applied. But then the third point is that the words in our state constitution have to be defined by their original public meaning. So it's not a question of what was in the mind of the male legislators. It's a question of what the public, including men and women, would have understood that word liberty to mean. Since abortion was criminalized at the time of the framing, no member of the public, male or female, would have thought that they had a constitutional right to commit an abortion.
So Griswold versus Connecticut is wrong. If the legislature wants to say women can't use contraceptives, that would be okay.
So we don't think, we're not challenging that, certainly, and we don't think that it's subject to challenge under our test. So there are deeply rooted privacy interests within the home that were recognized since the time of the founding. What's not recognized is a right to abortion, which causes harm to a third party, as the court made clear in Casey that abortion is a unique case. Abortion is different. And again, the laws of the state of Iowa, since the very framing of the Constitution, demonstrate how different it was. So in 1868, this court said that abortion was, quote, abhorrent to all our notions of sound morality and to all the precepts of our holy religion, because it is highly dangerous to the woman and it's fatal to the child. So it's hard for me to imagine how a court today could read into the word liberty, as it was adopted by the framers of the Constitution, a right to do something that was abhorrent to the morality of that day and would never have been understood by the original public meaning.
State courts, I think, by my count, and maybe I'm off by 1 or 2, but there's 17 state courts that have considered whether there's a right to abortion under the state constitutions. 13, I believe, have found a right, and of those 13, I think 7 apply strict scrutiny. Don't hold me to the numbers, because there might be some issues, but that's roughly correct. So those cases are just all wrong.
Read every single one of those cases to know what analysis and reasoning they might depend on, but I know in reading this court's 2018 decision, this court failed to apply neutral principles of law in reaching the outcome that the court reached there, including making sure a fundamental right is deeply rooted in history and tradition, requiring the plaintiff to prove his heavy burden that the statute is unconstitutional beyond a reasonable doubt, making sure the words in the Constitution are defined by their original public meaning, making sure a plaintiff bringing a facial challenge satisfies the no set of circumstances test, and then giving deference to district court's factual findings on adjudicative facts like witness credibility, which was at issue in that 2018 decision.
The decisions of this court going back for decades that the Iowa Constitution is a living Constitution. Now, those are the words that I'm drawing from our cases. And
Mansfield, in his dissent, and the 2018 decision did a good job of distinguishing those cases. None of those cases say it's living in the sense that the courts are entitled to make up new rights that never would have been recognized at the time of the framing. What those cases indicate is that it's living in the sense that it can adopt and react to legislative enactments dealing with new societal problems. And so what the court did in a 2018 decision by saying that the Constitution of Iowa is a living document which can create new rights rights and thereby take those issues off of out of the legislature's hand is really the opposite of what those three cases that this court, the majority, relied on. This is really a legislative issue that should be left to the legislature. The Constitution certainly can respond to new legislative acts, but it should not be read to create a new right to take an issue away from the legislature that always, throughout Iowa's history, has been understood to belong to the legislature. And Abedili, in this court's 1970 decision, decided, right before Roe v. Wade, it demonstrates that the state of Iowa was still prosecuting abortions all the way right up until the very end when Roe was decided and the legislature was taken off of the table the issue was taken off of the table for all state legislatures nationwide. We're just asking this court today to return the court to a position of neutrality on the issue of abortion, to apply those neutral principles which should have been applied in 2018, and for that reason to return the issue of abortion to the people and to the people's elected representatives. I see that I'm out of time. I'm happy to continue answering questions.
Anybody else? Okay.
But otherwise, I'll rest on our brief and ask the court to reverse the decision below and to remand for application of rational basis review. Thank you, Your Honors.
Ms. Bettis Austen?
Thank you, Chief Justice, and may it please the court. The state and Alliance Defending Freedom want this case to be something that it's not. It's not a case of first impression, of course, and it's not a case that squarely or properly presents the question of whether abortion is protected under the Iowa Constitution or whether strict scrutiny or undue burden is the appropriate test. That's for numerous reasons, and they are all about process. Process is what this case is really about. In the future, this court may be presented with an abortion law which doesn't violate the single subject rule, or a case in which the state can say that it's met its burden in our summary judgment process and point to any dispute of material fact that it could use to argue changed circumstances impacting the factual findings of the previous decision. It would then have any basis to argue that issue preclusion shouldn't apply. Or
The factual basis that they're precluded from litigating, what exactly is it?
the district court applied issue preclusion narrowly here. It applied issue preclusion to two factual findings. One was whether mandatory delay laws change women's minds.
All right, is that a factual determination, or is that your opposition says, well, that's legislative fact rather than a judicial fact?
The state cites no case for this distinction between issue preclusion applying only to facts between the parties or so-called constitutional or legislative facts that go beyond the parties. And there is no basis for that distinction in the law. And actually,
A legislative fact that the courts found as a matter of law holds true in all circumstances. It seems like typically a fact would be a fact relating to a party. This party, this person did not change his or her mind. So give me an example of a fact that we just can't change that's related to this one.
well, I would say that in this case, the fact is not specific to the parties. So the fact of the matter,
Example. So in our juvenile sentencing jurisprudence, we've recognized facts, social facts maybe, research, that the juvenile brain works differently and develops differently over time. And that's new kind of medical literature. As a court, are we precluded from considering that because 50 years ago we had a fact that anyone who's an adult offender, they all think alike and should be treated the same? To me, those seem very similar. And if there's new research or new studies, I don't know why the court can't reconsider it.
two important responses to your question. One is to make clear that the question of how long issue preclusion applies is not Never. It's not now because the state, at summary judgment, did not point to any dispute of material fact that the facts were not different as between the previous case and this case. And so the state could have, as Planned Parenthood did, introduce expert affidavits, put forth any evidence into the record to show that there was any changed circumstances that would justify departing from the normal circumstances of issue preclusion. It actually had every opportunity to do that. This case was before the district court for 6 months, and the normal rules of summary, 7 months, pardon me, normal rules of summary judgment, civil rules of procedure, issue preclusion apply to the state. It's subject to the same burdens that all parties are. Planned Parenthood put forth really undisputed record evidence. It was incumbent on the state to dispute that with any factual evidence. You know, the district court found that it had made these vague and hypothetical arguments about how things could be different, but that's not enough on summary judgment.
Follow up on this issue preclusion. You would agree that in order for issue preclusion to apply to a finding, that finding has to have been essential to the judgment. That's what our cases say, right? Well, once we held in the case 4 years ago that it's a fundamental right, strict scrutiny applies, right? And under strict scrutiny, the law had to be narrowly tailored, and as I read the chief's opinion, what he said is it really doesn't matter if the law maybe allows some women to change their mind. It applies across the board to all women, so it's overly broad and unconstitutional. So the finding that you're talking about strikes me as one that's not essential to the judgment. Am I missing something?
Two factual findings to which issue preclusion apply here. One are the burdens that are imposed on women by the 2-trip mandatory delay laws, and that goes to the narrow tailoring that your question is focused on, and whether the law swept too broadly, and it did, because it didn't have any exception for victims of sexual assault or domestic violence, low-income women, women who lived a far length from the clinic, that sort of thing. And
If this is a rational basis test, then aren't those calls for our legislature to make?
well, two things, if I may just finish answering the previous question and then I'll answer yours. So the other factual finding is whether mandatory delay laws change women's minds. That is, do they advance the state's interest? And so those factual findings are relevant whether we're looking at an undue burden standard or a rational basis standard, because if mandatory delay laws don't change women's minds, which they don't advance the state's interest and aren't rationally related to them. But of course, rational basis is not the standard. And stare decisis does not even allow this court to really engage in the question of whether rational basis or undue burden or strict scrutiny is the standard, unless we have more. The state's argument is very simple. It is just that it disagrees with this court's prior precedent, and that is not enough under principles of stare decisis. Under principles of stare decisis has to lapse. The state has to be able to point to anything, changed facts, changed foundation in the law.
Enough here, if we found the 2018 ruling to be clearly wrong, wouldn't that be enough to change the legal standard?
Not under principles of stare decisis. More is required. So stare decisis.
Just recently, we filed an opinion, State versus Kilby, that overruled a Fourth Amendment or Article 1, Section 8 case regarding search and seizure that was, I can't remember, 3 or 4 years old. And the rationale was it was demonstrably wrong, and we fixed the error. So on constitutional matters, it seems to me stare decisis has very limited implication.
Kilby went beyond a manifest error inquiry and looked at practical problems on the ground demonstrated by experience problems with law enforcement and court ability to administer the rule that the court was changing. So I would disagree with that characterization of Kilby.
Decision be so wrong. I assume, your organization doesn't recognize stare decisis effect for Gregg versus Georgia, do they? The death penalty case from 1976.
To you is that the stare decisis analysis is the stare decisis analysis. Stare decisis doesn't mean that precedent is blindly followed in all circumstances, but stare decisis establishes a framework for determining when a case can be overturned. And mere disagreement with a prior precedent is not enough. In the prior Planned Parenthood case, in your dissent, you acknowledged it was a close decision, even under the undue burden analysis. And so that sort of distinction is insufficient to show the type of clear error here, especially when there hasn't been a lapse of any stare decisis.
Defend myself a little bit. I think I said it was a close case under the undue burdens. I didn't believe necessarily it was a close call between my dissent and the Chief's majority. I thought my dissent was correct.
I understand, Your Honor, and my point goes to what is required to show clear error. And more than mere disagreement is required here. But
So Dred Scott or Plessy, the court has to wait some period of time before it fixes those?
Your Honor, this is not Dred Scott and this is not Plessy. This was a carefully considered decision by this court based on a full trial with factual findings. And this court took a careful and deliberate amount of time. This wasn't a rushed decision in any way. There just are not the factors that were present in those cases to reverse the prior Planned Parenthood case here. But
Right into it then. What, your opposing counsel proposes an undue burden test of some kind and maybe a rational basis test of some kind. Let's start with undue burden. What's wrong with, why is undue burden not the right answer?
Well, Your Honor, I would say even if this court were to adopt an undue burden standard, that it should affirm the district court decision based on the burdens that are present in Iowa, and Casey is not enough. But this court should not adopt an undue burden standard because the prior decision was consistent with this court's case law on substantive due process that recognize the decisional autonomy and the bodily autonomy interests that are implicated by restrictions on abortion. And, this
Laws going back a very long time where that doesn't hold as a constitutional matter, right? We have laws against suicide. We have laws against bigamy. We have laws against incest. We have laws against doing drugs. Don't all of those things sort of cut against this liberty argument here? I mean, right? That laws have protected people from sort of personal issues?
The dissent in the previous precedent recognized that originalism is not the only tool of constitutional interpretation, and certainly since the founding of this state, the dissent recognized that there is a body of binding precedent that this court has decided, Olds and Kennedy and McCuistion, Callender v. Skiles, which all recognized these substantive due process rights, and that it was reasonable to look at those cases and understand that abortion rights implicate the substantive due process rights that were protected and at issue in those cases. So I just want to emphasize that this question of what the appropriate standard is one that the state hasn't even properly put in front of you. It hasn't done the work to be able to do that. It can't overcome the single subject rule violation, and it can't.
Medical procedures what's wrong with the argument that says, well, we're going to defer generally to the process? I mean, we don't want to be blue penciling what the legislature's doing on a daily basis. This isn't like smuggling abortion into the code editor's bill. They both deal with medical procedures, do they not? Both the regulation of minors and abortion.
Broad umbrella topic is so broad that it would render the single subject rule meaningless. And we know from the case law that it's not meaningless. It's meaningful and it's mandatory. If the state's framework were the constitutional test, which it's not, then we wouldn't have had the outcome that we did in the Taylor case, because this court would have been able to find that a weapons trafficking provision was fell under some broad category, like some of the categories that they're suggesting: public safety, health and welfare, safety of juveniles, crime and punishment. Any of those things would have been broad enough to encompass both the underlying juvenile justice bill and the weapons trafficking bill. So we know that that sort of broad umbrella subject is not sufficient. And we know that the single subject rule is one that our framers adopted with purpose in order to prevent surprise to legislators and members of the public, and to prevent log rolling. And
Subject here a minute. If the burden is, or if the standard is undue burden, and I would like to talk about this proposed statute in particular regarding 24 hours, is 24 hours really that unreasonable? I mean, I've sat in an emergency room for 10 hours waiting for some attention, or perhaps maybe resources of Planned Parenthood or anyone else. Is there any way to ameliorate that two-trip problem by having some place available for people to stay overnight, for example? I'm just trying to figure out, how is 24 hours incredibly unreasonable and not even to the undue burden standard?
two things. One is that there is uncontested record evidence in this case that these burdens would not just be, and the delays would not just be 24 hours. So the burdens as between 72 hours and 24 hours are the same because of the delays in getting appointments scheduled, both in terms of provider resources and the realities of patients on the ground. So it's not 24 or 72. In both cases, the delay is much longer. But even if the court were to change the standard to undue burden, I would point out the state's argument really is just under undue burden. Well, Casey was a 24-hour law, but that's not enough. If you look at the record that the court had in front of it in Casey, it was entirely different than the record that's in front of this court now. And so, for example, in Casey, there were 81 clinics. In Iowa, there are 6, 2 of which provide procedural abortion. There was scant evidence, I think around 1% in the record in Casey, that abortion patients were impacted by domestic violence. The record in this case is that over 13% of Planned Parenthood patients seeking an abortion have experienced physical abuse or sexual abuse. In Casey, there was an assumption that waiting periods change women's minds. And in this case, there is an unrebutted record on summary judgment that they don't. And that those are really just some of the differences.
In my prior life, I was an adoption lawyer, amongst other things, and if somebody would come to me pregnant and want to place their baby for adoption, we never did all the important paperwork, or if they had a newborn already. And there were people who changed their mind after talking to me, or maybe just chatting with their friend or whatever. But even if it's only one person, let's just say it only changes one person's mind, is 24 hours really that unreasonable?
Your question goes to, do waiting periods change women's minds? And the state has not put any evidence in the record that they do, and the unrebutted evidence is that they don't, and that's for 2 reasons. One, most women, by the time that they make the appointment, have given serious thought and consideration to their decision.
By that argument, it doesn't change their minds. Just like wedding licenses, I don't think you have to do that anymore, but it probably didn't change anybody's mind either. But it just, if anything, it's just our state believes, hoping, crossing their fingers it will, Is that really so unreasonable to wait?
Reasonable because of, under strict scrutiny, I know your question is under an undue burden framework. So it is unreasonable because of the burdens that it places on women seeking a pre-viability abortion. And those burdens are much greater than a 24-hour delay. We know that from the uncontested record. And the state has to point to more than just hypothetical arguments to be able to counter that. But I just wanted to also mention that, also in the unrebutted record here is that the providers, if women are unsure, they don't provide an abortion that day. That's part of why these mandatory delay laws don't impact patients changing their minds. Because if patients are uncertain, under the existing informed consent protocols and patient counseling protocols, those women are asked to take more time. If they'd like to carry the pregnancy to term, they're given resources to do that. And so these are all part of the reasons why the state has not been able to generate any dispute of fact as to the impact of the waiting period.
In this case, mirror the record in the first Planned Parenthood case, namely that 63 counties don't have an OBGYN in Iowa. Is that in this record?
Parenthood submitted 5 expert affidavits that all agreed that the burdens that were found in the previous case were the same as between 72 hours and 24 hours when it comes to impacting women seeking abortion. And the state had the obligation, if it wanted to be able to point to any dispute of that fact before this court today, to actually do discovery, try to put any evidence in the record. It didn't do that. And so I would just say, the state's conspicuous inability to point to any dispute of fact made it impossible for the district court to deny summary judgment to petitioners. And on stare decisis, its inability to point to anything, any changed facts, any lapse of reliance, any changing development in the law, means that its arguments to overrule are meritless. The district court was right to rebuke the state's arguments, and we respectfully ask this court to affirm summary judgment.
Thank you.
Thank you, Your Honor. I'd like to briefly start with the single subject. Ms. Bettis Austen brought up Taylor and suggests that this would be, a strong reach, out of this court's precedents. And this court has said that, a 27-line, 300-word economic development bill is all, or that was the title, and an economic development bill is one subject, that the entire criminal code is one subject, that, code corrections stretching through all the volumes are one subject. Taylor really is not an issue about the scope, because we know that a bill could have had juvenile and criminal law, in it if that was the subject. But the court, in both a title challenge and a subject challenge, concluded this was really a juvenile justice bill. The title only talked about a juvenile justice bill, and we snuck in there's an adult criminal provision in there, and that's not the same subject. With respect to the summary judgment motion, and Ms. Bettis Austen repeatedly talked about not generating an issue of material fact, and that's because the issues presented at summary judgment were legal issues and were not a fact issue. Planned Parenthood filed an issue preclusion motion for summary judgment. You can look at the motion at Appendix 44. They had one item, one paragraph, on Appendix 55, that was their statement of undisputed facts about, changed circumstances. And the state's response to that, which was at Appendix 524, is that because issue preclusion is a question of law, and they're asserting that we cannot defend this at all, we're not going to ask for a continuance under the summary judgment rules, as we could do if we wanted to develop more discovery, because that isn't necessary to resolve the question they've presented, which was an issue preclusion motion for summary judgment, and not a standard factual motion for summary judgment. So the factual disputes, and it was not at this juncture, a burden on the state, and this court's not required to find that there are factual disputes when the district court granted summary judgment to prevent us from continuing to defend that statute.
To your question about what was preserved and what wasn't, and Article 1, Section 1 of the Iowa Constitution. Don't see that in the briefing. There's a footnote, I think, in one of the briefs related to it. But would you just briefly share with me your view of the status of a claim under Article 1, Section 1?
Sure. The Planned Parenthood did not address Article 1, Section 1 in their motion for summary judgment, because again, it was an issue preclusion motion for summary judgment, and that was not an issue that was decided in the 2018 decision. So it makes sense. Correct. Presumably they could advance a new argument based on that if this case were, went back and proceeded. But I think that's evidence that, this was an issue preclusion, motion, and so it's not here.
Kansas decision, correct? Kansas fundamental right was inalienable rights clause.
I'm not 100% certain, Justice Mansfield.
The U.S. Supreme Court's going to announce an abortion decision by the end of June. We have a long line of cases where we've held the Iowa Due Process Clause has the same purpose, scope, and effect. Should our court wait to see what the U.S. Supreme Court does?
The court certainly could. We think it's not necessary to do that. I mean, the court also, has repeatedly, in many cases discussed that it's got an independent duty to decide what the Iowa Constitution is. Planned Parenthood, notably, is not bringing a federal constitutional claim here. That's not in this case. That's not in this case at all. And the current 2018 decision went well beyond the federal standard. I mean, the fact that the federal standard is being debated and the subject for debate, I mean, is one of the reasons we're not explicitly advocating that's the route. It would be odd perhaps to latch on to a federal standard that may not be around. But it is appropriate to reach the question here now. The fact that 2018 is manifestly erroneous is enough to abide or to reject that decision. There was nothing unworkable about Plessy versus Ferguson. As a standard, separate but equal, was pretty clear. But it was wrong on the day it was decided. It should have been corrected the day after it was decided, and the state would ask you to correct the 2018 decision now as well. Thank you, Your Honor.
Parenthood versus Kim Reynolds and State of Iowa and Board of Medicine is hereby submitted to the court. We'll take a brief break while we get ready for the second oral argument.